Welcome to Policy and Politics with me, Tarun Nangia. You would have seen in the past few weeks cases of money laundering have been in news all over. Many high-profile people have been booked under this law, which is the Prevention of Money Laundering Act. Well, there were also issues in news that you would have read regarding attachment of assets, bungalows, factories, gardens, things that people own as part of their asset profile, cars, jewelry, all of these things. So attachment you would have seen, possession you would have heard about, also the whole issue of proceeds of crime. Today we have an expert who deals with these cases on a day-to-day basis. He'll take us through the whole issue of when businessmen are raided, what is attachment exactly, what are proceeds of crime, what is possession, and when possession is taken, at what point possession is taken. Is there any way to get out of your, in a sense, assets being taken possession of? What is the legal remedy you have? All of this and more. Let me welcome Advocate Malak Bhatt. He's founder, partner of NM Law Chambers, a law firm that specializes in financial crimes. Good to see you, Mr. Bhatt, and thank you for your time.
Thanks, Sam. It's always good to be back.
At the outset, in the first 3 to 4 minutes, if you could take the viewers through that how proceeds of crime, a word that they hear often after somebody is raided, is different from money laundering as such.
Sure. So let's start with the basic first principles, because the viewership that we are addressing is also people who will be facing this, but at the same time may not know the bare essentials of it. So if you look at the definition within the ambit of the PMLA, proceed of crime is defined as any property which is derived or obtained out of the commission of a criminal activity. Very interesting part of this is that the general misnomer that we've seen happening, and that's also how the agency has been acting, is to try and pinpoint every and any asset belonging to that person or to that entity which has any nexus to the criminal activity as a proceed of crime. But that's not how the Act envisages it. The Act specifically says that for the purpose of pinning something to be a proceed of crime, a proceed which is generated out of the crime, it definitely has to be derived or obtained, maybe directly or indirectly, but it has to be derived or obtained from that particular criminal activity for it to be given the cloak of a proceed of crime. Again, the mere generation of proceed of crime is not by itself an act of money laundering, because what is required under Section 3 of the Act is that there has to be an additional attribute that the person has to give to that proceed of crime for it to actually amount to a criminal offense of money laundering. So, for example, let's take this very close to a simple example. If someone robs a house, and while that person is leaving the house gets caught, what is today in his hand is money which he has derived out of a criminal activity, because the criminal activity is of theft. But does the fact that he's possessing it while he's caught amount to an act of money laundering? The logical answer would be no, because he has not attributed any further act to it to actually launder that money. But if you take this forward, that the money is actually given to B, who then tries to utilize it or layer it to show it as untainted money, that's where the person really comes in the fray of money laundering under Section 3. And in fact, at this point, I'll just stop for a minute. Interestingly, this issue was recently raised before the Telangana High Court in a case concerning a company called MBS Impex, where they had sought for quashing of the ECR against them. The case was on a very simple footing, that there was the predicate offense was an allegation concerning collusion with officers of a public corporation, for which the company derived certain benefit, in the sense they did not have to give money which they otherwise would have given. On these facts, while the predicate offense was ongoing, the ECIR was registered and the petition was filed for quashing. The Telangana High Court gave a very interesting finding and a very interesting interpretation to Section 2(1)(u), which is the definition of proceed of crime, to say that merely because you were required to give some money but did not end up giving it because of whatever benefit you gave, does not mean that you have actually derived an asset out of your criminal activity, because what you are holding is still your assets. It's not as if the asset is generated out of the proceed of a criminal activity. So therefore, they said that the very fulcrum of the case goes, since this is not an act where there is any procedure of crime at all. And today this matters before Supreme Court. So it will be interesting to see how Supreme Court now looks at the definition of procedure of crime. But I think generally there is a very loose misnomer as to what a procedure of crime is and how a procedure of crime will ultimately lead to money laundering, because not every asset or any property absolutely held by you will automatically become procedure of crime because there is a ED prosecution ongoing.
Point well taken. We will now take this issue towards the issue of attachment, the powers of the enforcement directorate, and the procedure regarding the same. Lot of promoters, businessmen, people who have been raided many times have this question: when are his assets or her assets liable to be attached? Is there any procedure regarding the same? And when does it become necessary for the attachment itself to take place? Could you take us through one by one through all these things?
Sure. So again, if you step back to the objects and reasons why the PMLA was promulgated, it was in the wake of the increasing laundering, which at that time in 2001, 2002 was regarding terror funding or drug money. And that's where it was felt that when it comes to money which is laundered and immediately layered, it is perennial to stop that at that very point of time by freezing the assets. And this today finds itself in the statute book in section 5 and section 8 of the PMLA. Now, interestingly, the powers given to the ED are wide, because it says that you can actually go and attach the asset which you identify as the procedure of crime itself. Or if that asset is not traceable, or you cannot identify a particular asset which would be a procedure of crime, you can attach the value thereof. Now, this is a very wide connotation, because what it means is that let's assume a case where one can actually say that from the procedure of crime generated in the hands of a promoter, he has actually gone and transferred that money to one of his entities. From that entity, the money has gone into a trust, and the trust has ultimately gone and bought a house. In such a case, the house is something which one can identify as a procedure of crime. But let's say it's a public service company, and money is distributed amongst various investors or individuals, where you cannot identify that particular procedure of crime in one hand. In such a case, the PMLA actually gives the power to the ED to go and attach the value of such assets. So if the ED comes to a conclusion that the actual proceeds of crime generated out of this criminal activity are, say, 200 crores, then they can identify assets worth 200 crores in the hands of the person and go and attach them. Now, here there are also, it's not as if it's this simple. There are also safeguards at every point of time. Interestingly, if you see the act, it actually says that an attachment, a provisional attachment, which is the first step of the attachment which the ED goes for, should ideally be done only once the charge sheet is filed, because it is only, or the complaint is filed, because once the ED files the complaint, that is where it has actually come to a categorical conclusion that yes, a laundering activity has happened, and that is where they are able to come to a quantifiable finding of what that laundered money is. But it has an exception, and in fact, unfortunately, the exception has become the rule as far as the current actions are concerned. The exception says that in exceptional circumstances where you feel that the assets will be dissipated and you will not get anything in your hand, that is where you can actually attach the assets prior to filing of the complaint, but it then has to be backed by reasons in writing as to why you are doing so. The procedure is that once the ED goes and does a provisional attachment of certain assets, obviously third-party rights cannot be created. The asset now stands in the hands of the ED for the purpose of notional attachment is concerned. But within 180 days of that attachment, the adjudicating authority set up under the Act has to confirm the attachment. And if the confirmation is not made within 180 days, then the attachment lapses. Now, I'll finish attachment first and then go to possession. When you talk about attachment, there are 2 or 3 safeguards which the law provides. Can the ED come and attach every and any property? The straightjacket answer to that is no, because the way law has thankfully developed by the Supreme Court, by high courts and also to an extent by the PMLA, is that if the asset itself is something which is generated or has been in existence in the hands of that particular accused prior to the very commission of the offense, then obviously, logically speaking, it cannot be a procedure of crime because it has no link to the crime. Let's say there's an ancestral house in my hand since 1960s, and the commission of the offense, which the ED itself alleges, took place in 2009. Obviously, the asset is not something which can be linked to the procedure of crime, cannot be linked even to the criminal activity. So the first principle is that any asset has to have some nexus to the person and have some nexus to the activity which is being generated, which is causing the generation of the criminal activity. Number two, in situations where the asset can be shown to have been generated from sources which are delinked from the procedure of crime, those are also assets which can categorically be protected. Now, let's take the simplest example here. A person is accused to be involved in a siphoning case of siphoning bank funds and then laundering that money into various others, either sister concerns, etc. A asset which is bought by him from a home loan. Let's say he has bought a house, but the entire funding has happened from a third-party bank and he has mortgaged that property. Obviously, it's an asset which cannot be linked to any part of the procedure of crime. So these are assets which obviously will also stand to be protected. Third, most importantly, is that the attachment has to bear in mind the relevance of attachment at that particular point in time. So the adjudicating authority has to be made to believe by the ED that the attachment, the reasoning for the attachment was imminent. There was a threat to the property being dissipated, and which is why the attachment was being done at a time prior to the complaint. And these are large scale of the arguments that we typically raise before the adjudicating authority. In most cases, they fall, but there is always an answer at the appellate forum or at the high courts. Interesting, and on this point, I'll just give you a very recent judgment that came out. Justice Yashwant Verma in Prakash Industries, which was a case which took place very recently, about 2 months back, said that, look, as far as ED is concerned, obviously you need a predicate offense on one hand to start an investigation into a money laundering exercise or investigating an ECIR. But if the predicate offense is A, your actions of trying to put more than A within the scope of an ED investigation cannot happen. So the case at hand basically was where a coal allocation was under challenge, and they said that this is the fulcrum of the predicate offense which has caused money laundering to take place. There was another ancillary issue where a share transfer had taken place. ED had tried to argue that, look, that share transfer also is a criminal activity and therefore we are attaching the shares. Court said, sorry, you cannot attach those shares because those shares are not part of a predicate offense. So your scope of investigation or the scope of your powers is centralized only to the extent on which the predicate offense is castigated. You cannot go beyond that. So tomorrow you cannot say, oh there is one offense which today the CBI or the EOW are investigating into, but you, Mr. X company, have done 10 other things. We will take all of that in the scope of our ED investigation and try and attach all the assets with respect to all those issues. That can't happen. And these are the issues which today the courts are readily trying to address.
But tell me, even after this, if the Enforcement Directorate A does a wrongful attachment, then the victim in that case or the accused, both, what legal remedies does he have? A, because he's an accused in the case, but he also becomes a victim if at all his property is wrongfully attached.
Right. So there, the answer is twofold actually. One, some part of the answer was given by Vijay Madan Lal Chaudhary's judgment, because large part of the risk that used to take place upon attachment and the confirmation of the attachment was the risk of eviction. The moment we used to practically see what used to happen pre Vijay Madan Lal Chaudhary is that once the attachment is confirmed by the adjudicating authority, typically while one has 60 days to file an appeal before the PMLA, the ED would land up on the very next day with an eviction notice, which typically is a notice under section 8, subsection 4, called a possession notice, and say, sorry, the attachment is confirmed, kindly give the possession to us. So you'll be running to the PMLA to file a appeal. Thankfully, Vijay Madan Lal Chaudhary clarifies this and look, an attachment is only to ensure that you don't sell this property going forward, or you don't create third-party encumbrances, so that the asset remains identifiable for the purpose of the ED. But that does not mean that you can be dispossessed or that the right of enjoyment of the property can be taken over. So possession to that extent, thankfully, has now become limited only in extremely rare cases where the ED feels that even the right to enjoy will create problems for them with respect to that property. Second part, obviously, an attachment on a property, especially properties which have revenue generation issues for a company. Most cases, for example, we've seen where in real estate companies, say there's an ED investigation ongoing, the ED has gone and attached the real estate inventory of that company. Now, for a company which is doing this as a business, if one goes and attaches the unsold inventory, they can't sell it. If they can't sell it, they can't generate revenue. If they can't generate revenue, it leads to a downfall of the entire mechanism for that company, the operations of that company. So this is where courts come to recourse, and here the remedies are twofold. If the process of attachment is as per the books, and the assets are assets which otherwise can be identifiable or traced back, having some nexus to criminal activity, then one has to go and fight the matter before the adjudicating authority and say, look, the attachment is wrong for ABC reasons. If the adjudicating authority confirms the attachment, the remedy lies before the PMLA, which is the appellate tribunal, which looks into these issues as to whether the attachment is valid or not. However, in cases where either the jurisdictional issues are involved, where the attachment itself is beyond the scope of ED's power, or if the attachment is of a property which could not have, even in the eyes of a reasonable person, be considered to be an attachment valid in law, or say attach someone else's property as part of my property on a loose understanding of nexus between two people, or for that matter, attach property which is much prior to the scope of the scheduled offense. These are cases where if the process is wrong or the jurisdictional facts are very weak on ED's grounds, then one can try and approach the High Court in a writ court in a writ petition and try and place this at a level to say that this is a situation where legal rights have to be protected under 226. And
I want to know this specific thing from you. Most businessmen or owners of property who are rated, they put their properties on rent via lease for 7 years, 8 years, 10 years. There are long leases. If that property is liable to be attached, then how does that function when a third party interest has been created in that property? Because that, I think, is in a sense a worry for many who also have been prosecuted, but most properties that they have are either on long lease or given to companies on lease, banks or various institutions. It's a fairly common problem. But how is it seen by the courts?
So this is in fact inbuilt within the rules itself, the PMLA rules, where if the property is not on rent when it was attached, then obviously you cannot put it on rent any further, because that's a creation of some kind of an interest on the property. However, mere attachment of a property which otherwise was already leased out or rented out, be it a short-term or a long-term lease, does not impact the tenancy in any manner. Because what the PMLA rules contemplate is that while the property stands attached, the rent which is being collected from that property is now rent which notionally identifiable is property belonging to the ED and ultimately to the central government. So the requirement under law is that you will then have to deposit the rent. You can keep the property on rent, but the rent has to be deposited by the tenant with the ED.
Oh, so the ED gets to keep the rent.
Correct. So that's as far as the recourse is concerned. However, how courts have actually seen this going forward, and a couple of cases have taken place at the PMLA also for this, is if the accused or if the person who owns the property can give some kind of an assurance or can can give guarantee to the court that the amount will be kept identifiable and separate, then that rent can continue in his hands, provided the rent remains protected to the extent that ED is able to either seek a rendition of accounts or the money is kept in a separate account. But the tenancy or the lessee's rights otherwise don't stand affected. And that's at least the good part of how this in the last 3 or 4 years has developed at the PMLA.
In your earlier answers, you said that if the proceeds of crime are not readily available for the ED to find out, then any other equivalent amount can be attached. So it can be jewelry, cars, anything of that equivalent amount. Which means what assets are easily at risk of attachment? Is it one primary home because that is the most easily identifiable asset? Is it the most prone to attachment?
So typically what we have seen again, as far as attachment is concerned, and this is largely a worry which most of the promoter clients face, is any identifiable asset which belongs to their immediate family is at a risk of attachment. This will include properties, immovable assets in the name of themselves or their immediate family, their son, daughters, their wives, mothers, fathers. Movable assets like gold, jewelries, mutual funds, bank accounts, fixed deposits belonging again to the family, provided there is a nexus which can be drawn to the entity or the person concerned who is supposed to be the perpetrator of the alleged money laundering exercise. So I'll give you a very simple example. If the wife is drawing salary, typically in most cases, what happens is that the wife draws a salary from the company concerned, or the wife is on the payroll, or every month mutual funds are being created by the company in some part of the family's name. These assets are the most obvious available assets for the ED to come and attach. And these, as far as practically the cases we've seen are concerned, do get attached. The way to target them is to ultimately show that these are assets which are independently earned by those people, and if cannot be linked to the actual act or proceed of crime being generated, then should be remedied directly at the High Court level.
I have one last question for you, but if you can answer it in a layered fashion. For example, if the ED is not able to find the proceeds of crime, they go and attach assets of equivalent value, as you said. That equivalent value is the market value of the assets being attached or the book value of the assets. And if it is the market value, then from what data is the market value derived? Because in India, market value and book value can vary greatly. How would you, in a sense, is it a uniform policy in the Enforcement Directorate for this?
Unfortunately, this is the part where it hurts the promoters the most, because for them, even if an asset is being attached, if the value of the property is given the right value, then most of the alleged proceed of crime will stand attached. Unfortunately, what we are seeing, and I'll answer this in two parts. As far as movable properties is concerned, the market value is taken from the determining factors which are available in the public domain. For example, I'll give you the best example is gold. So the value of the gold is taken from the current day, on the day on which the gold is attached, multiplied with the actual quantity of the gold. Mutual funds are given the rate on which the mutual fund for that day is existing at. Shares are attached at the rate on which the publicly traded shares are being traded for that day if it's a public listed company. Now comes the problem with respect to immovable properties. In most cases, what we have seen is that the immovable property is given, or the value is taken on the date on which the sale took place. And it will typically be as per, if there's an existing sale deed, the property's value will be taken as of the sale deed, or they'll take the book value which is existing on the books of the company. Meaning thereby what happens is that the inflation, the escalation on a year-on-year basis, and the actual market value are given a complete go by. We have actually seen practically cases where assets worth about 50-60 crores are taken at a value of some 17 or 18 lakhs, because that's the value which was existing on the books of the company for more than 35 years ago. And that is something which then has to be fought before the adjudicating authority, that the very action of ED is wrong because they are not able to ascertain the actual value of the proceed of crime. This issue also comes up very regularly in attachment of shares of companies where the share value is not ascertainable otherwise. So closely held companies, typically it should go by the turnover of the company. You can do a GMV, you can take a DCF method to come to the value of the company, but no, what they actually take is either the face value or the book value of the shares, which, as you know, as far as accounting is concerned, the value is always notional and nominal. And these steps are hurdles which then one has to cross at the levels of adjudicating authority and PMLA. But again, since it then will come to a question of whether the attachment is actually valid or not, it's a long drawn process.
So basically, this problem needs to be addressed by the courts of law sometime in future.
Absolutely.
Because so it was an interesting conversation with you, Mr. Bhatt. You took us through the whole issue of attachment leading to possession, proceeds of crime. What if proceeds of crime aren't traceable? Also, the lacunas currently in the law which need to be addressed. We'd like to revisit this issue in a month's time. Seeing the number of high-profile cases, there are ongoing doubts that are generated in the minds of so many people. Sometimes different views taken by different courts lead to some kind of doubts in terms of how a case is to be treated. We have seen cases, courts in different states taking different opinions on an issue. That also, of course, we would like to take up with you in future. But thank you so much for speaking to us on attachment, possession, and proceeds of crime under the Prevention of Money Laundering Act. Thank you for tuning in. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.